everyone. I hope that I'm visible and audible to you all. Give me a thumbs up if I am. Okay, thank you so much. So we'll be having our session for criminal drafting, and it will be a very easy and smooth ride, let's hope. And we'll be covering several topics related to our main topics. And I'll keep it short, crisp, and nice for you all. I hope it will all be in simple language. So no need to worry that it will be too complicated. If you guys will have any questions, I will not, stop you from unmuting your mic. We'll take questions as well. As I said, it will be an interactive session. So let's get into it. Let me just share my screen. So we are here for the criminal drafting, and our topic is essential skills for criminal drafting, and we'll be discussing everything related to that only. And I hope that I'll be able to cover as much as possible. So let's begin. So the topics for the day will be a complaint, FIR, bail application, appeals, and revision. So this is all what is included in a criminal file, and we should know as a lawyer how to draft such documents, and we'll be covering all about them. So let's get into it. So first of all, you need to know, we'll start with a complaint and what it is. So section 2D of the Criminal Procedural Code 1973 defines a complaint as an allegation made orally or in writing to a magistrate with a view to his taking action under this code that some person, whether known or unknown, has committed an offense but does not include a police report. So right now here you have to see a few words where you have to focus on few words. That a complaint can be oral or written. Okay, it can be oral, it can be written. It does not have to be a written document. Now that complaint has to be submitted to whom? That is your magistrate. A magistrate is a person who you are supposed to submit your documents, submit the application to. Then what it comprises of is that any person that you know or do not know has committed an offense, and it does not include a police report. Now police report is something that something happened, somebody committed an offense, and police go through the investigation and everything, and they make their own report. They write everything, all the facts, all the required thing in a report. That report given by the police is known as police report. So your complaint does not include that. So this is the basic definition that you must remember if somebody asks you what is a complaint. Okay, now we will look into a complaint, that how it looks like. So let me see. We have it here. Is it visible to you all? Okay, thank you so much. So now you can see here it is written complaint. Now first of all, you'll have to mention the address of the complaint. You'll write so and so house number, or so and so area, or so and so city, and with the pin code and everything. You'll write it properly. Whoever the complainant is, you have to write it properly. Next, you go for the date, which will mention the date, first, month, and then the year. Now, since you are doing it in a police station, now you can go directly to the magistrate, but that involves a lot of multiple processes to that. because your complaint does not directly go to a magistrate. Okay, even though that it is written that you can go to a magistrate for a lot of things, there is a process that you will have to follow. So the easiest way is to go to a police station, ask a policeman to help you with it. They'll guide you with it. But as a lawyer, considering the fact, if this all is for a layman, okay? But as a lawyer, considering you are drafting this complaint, you will write the address of the police station properly, like the way you write the address of the complainant, and then you will write the subject of the complaint. Now, subject of the complaint can be, I saw this specific person committing a theft in this specific area. So your complaint subject will be a complaint for reporting a theft in such and such area. Now, sir and ma'am, directly, indirectly, it goes to the magistrate. So we are referring to them only or the inspector. Okay. Now it is saying that I am this person. Now who I am is referring to is your complainant. Okay. Even though you are drafting, this document belongs to your complainant. So you will mention all the details about the complainant only. So who the complainant is, where does he reside, and here he writes how long he has been living there, and his house number. He was tried to rob yesterday on the date. So you write everything about the incident. So here this incident is about a robbery in which he and his family were subjected to a little shock and a lot of things that happened to him. This was a clear crime against him and his family, and he is reporting that only. So he mentions his name, his residence, his house number in which they entered, and on which date. You can also include the specific time frames if it is required, so, and then you will tell every detail which is necessary in the document, because that impacts that makes an impact. Okay, you will mention everything, with a sequence, how it happened, by whom it happened, who did that. You will try everything. You will say everything on the document. Of course, there has to be a limit. It has to be a very, it should look crisp, at the same time very informative to the person who is reading it. Now, this paragraph is explaining how it has, affected him, his family, and the society. Remember that an offense is a crime against the society. So that is why he is mentioning that other colony members are worried too. So it is showing that how it affected the society near him, and thus it was necessary to mention, and this matter, and this makes this matter very important to deal with. Now, once he has explained everything, once he has mentioned everything, it's not a very complicated document. He said what all was supposed to be said, and then he shows his regards. He says, thank you, yours faithfully. He puts his name here, which you will do, of course, and then you'll make the complainant sign this document. Okay, let's come back here. So up until here, are there any questions from you guys? I'm hoping for questions. It is an interactive session, Any questions? If you are shy or hesitant of publicly speaking, you can leave it in the chat box. Also, I will answer you from the chat box as well. Okay. So I think that nobody has any questions up until now. So shall we move further? Give me a thumbs up.
Yes, ma'am.
Thank you so much. So let's go back to the PPT and see what was there. Just a second. Yes. So we have done complaint, and now it is about FIR. So Anybody who can answer me, who already knows what is an FIR, English, Hindi, whatever language you want is okay with me.
Ma'am, FIR is a first information report which is filed when the offense is cognizable.
Mm-hmm. And if I'll ask you to explain it to a person, for example, you have this client who is not literate, okay? Now you'll have to explain them. No, then in a very simple language, what you'll tell them.
Ma'am, they have to explain the complaint in the their as per
Mhm.
their comfortable language.
Yes, whatever your comfortable language. Yes, I'm asking, considering the fact that you are lawyers, you are going to be lawyers, how will you tell a layman person, a layman who is not literate, who is there for your help? What will you tell him about FIR in simple language, very simple language, any one of you?
Ma'am, so basically, FIR is a first information report. So you have to tell the layman that the minute that the incident happened, from the start to the end, whatever has
Mhm.
happened, you have to explain it to the police without
Mhm.
missing any of the details in in a very informative way, so that the police makes a
Mhm.
report out of that incident so that they can use it for the further investigation.
Very good. Who it was? May I know your name, please?
My name is Kritika.
Very nice, Kritika. You were almost there. So this was very much informative for all of us. I hope that you all will remember this. So now let me explain you, as it is my job to. First information report is a written document. Now, this is the difference between a complaint and an FIR. It is a written document. Specifically, it has to be written on a pen and paper. You cannot give it orally. Okay? It is prepared by the police. Okay? When they receive information about the commission of a cognizable offense. Okay? Now, what happens is that some crime happened. Okay, somebody committed some offense which is cognizable offense, and then uh, you know it is committed to you, and now you want to seek for help. Huh? So you'll go to the police station. You'll tell them that this happened, and now they will make this particular document about what information that you have given to them. Now, since you are coming to them for the first time, huh? So this is the first information that is given to the police by you, that such and such offense has been done to me, such and such wrong has been done to me. Now, this is the first information that you have given to them, and the report which includes it all, the report which includes all the information that you have given to them, the layman has given to them, this report is known as first information report. Remember that it is a written document, it is prepared by police, it is for the commission of cognizable offense. Now, where it is defined under section 154 of Criminal Procedural Code and section 173 of Bharatiya Nagarik Suraksha Sanhita. So I would suggest you all to go, at least considering the fact that it is internship time. I am thinking that you all know about the fact that we are going to have new rules from July onwards. I would suggest you all to, at least go through them once so that you have an idea what has been changed, how they are doing it. So before going to this, we'll go to the document and we'll see what is happening. Okay. So here is a sample of FIR. One second, let me fix my screen. Okay. So now in this sample FIR we have here, and here it is written. First of all, from whom? So you'll write the applicant's name, the father's and husband's name. You write it as son of, daughter of, wife of, like that. And then the applicant's contact address. It can be anything. Uh, the house number specifically, you'll have to mention the house number. Then you have applicant's contact mobile number, phone number. So in any case, the police wants to contact with you, they can contact. Now, if the applicant has an email, you can also mention that into the document. And then there is date. You'll mention the date of submitting the application. Now, two, the police officer in charge, address, name of the local police station. Of course, we are going into a police station for this. So the name of the local police station. Then the subject. Mention that maybe that here it is given you have lost a document, phone name and number. Let's say that you have lost your mobile phone. Somebody stole it. So you will mention that. Now, in this particular example, they have written to Proctor AMU Aligarh. It is about Aligarh. Respected sir, I would like to bring the following facts to your kind notice. Something happened. I was in here. I was in this specific area, and somebody stole my mobile phone. At this particular time, let's suppose 4 o'clock, I was in the market and somebody stole my iPhone, which was of white color. It had a green color wallpaper in it, and it had my name on the case of it. And around 4 o'clock, it was stolen. And now I am seeking for your help and request to kindly register my FIR in the subject matter. Okay. For you, ready reference I include herewith a copy of complaint. Now, before this, you have also, you have also complained about the same. And after the complaint, it comes to the FIR. So you will attach the copy of your complainant's informative ID, including everything. And then hope you will very earliest. These are the things that you are supposed to write. Then there is your regards, signature, and the name. And you should make 2 copies of this application. Always remember, one is for the police station, and other is for the use of your personal. Okay, one more thing, guys. Am I audible to everybody, or my voice is not clear?
Ma'am, you are audible.
Am I perfectly audible to you all?
Yes, ma'am.
Okay,
Yes,
thank you
ma'am.
so much. If there is any disturbance and I'm not audible or visible to you, or the screen is not visible to you at any point of time, do let me know about it. Okay. Okay, thank you so much. So we were here. So this is how your FIR is supposed to look like. Remember the way you mentioned all the facts here, all the facts you mentioned here in precise way, in detailed way. Similarly, you have to do in the FIR, how it happened, who did it, whatever happened, you will have to mention all the informative part. Okay. Do not make it, too long. It just has to be precise and informative. Is it clear to you all? Thank you. Now let's go back, and we have our bail. So first of all, bail, what is a bail? Now, bail is a procurement of release from prison of a person awaiting trial or an appeal by deposit of security to ensure his submission at the required time to legal authority. Now that I have read it for you, uh, if anyone is ready to volunteer, what is a bail? Is there anybody who would like to volunteer for that question? Okay, I don't think so. Let's go with it. So what happens is that let's suppose that there is Raju, okay, and Raju is accused of Raju is accused of committing a theft, but he might be, it will take a lot of time for the investigation and everything, and he cannot stay in the jail forever. Or there is some other person who has done something who is actually a culprit. But in some case, when you are in the jail or about to go to a jail, let me be very specific with this. You are supposed to deposit a security to the court. Okay, security can be anything. Let it be money, property, or by some person. It can be any. And in the trial court for an appeal, you'll mention it and submit this bail application. That whenever you will be called, you will be there in the court. But for the time being, or for a specific time, you request the court to let this person out of the jail so that he can do so and so, what for whatever reason he is going out. That person can do whatever he is supposed to do. Is it clear to you all? Anyways, let me just tell you once again, as I think that it was not, up to the mark for my standards. Bail is a document for which you deposit a security to a court, and then the legal authorities allow you to be outside of the jail, to go outside of the jail, even if you have if you are accused of a crime, if you have actually committed a crime, and then you go out, do whatever responsibilities you have, and for the time being this bail application works. Now what kind of bails there are? First of all, bail in a bailable offense. Okay, bailable offenses are those offenses in which a person can get a bail. For example, theft. Very small, very small offenses that there are, they are usually bailable. And then bail in a non-bailable offense. For example, there is a murderer. Huh? It is not bailable. The offense is not bailable. You cannot go outside of a jail, but there is some urgency and you have to be out of the jail. Then in those cases, the bail is there. And anticipatory bail. Now, what do we mean by anticipatory bail? Now, anticipatory bail is a bail which you make in front of the court, which you request in front of the court before even getting arrested. Okay, let's suppose you have been accused of something and it is all over the media, and then it is all over the media, and you know that somebody, the police will arrest you for the same. Let's suppose that the recent Porsche case, it was all over the media, everybody was arrested. So if I was the kid who did the Porsche thing, the Porsche offense, then I would know that I'm going to be arrested. So in this is a very big case, of course. This is a very serious thing. So let's suppose it would have been a theft only, and I knew I am going to be arrested for the same. Okay, if I'm going to be arrested for the same, then I would ask my lawyer that I do not want to stay in the jail. Kindly help me with the bail. So now, what you will do as a lawyer, you'll make a bail application since you know that this person is going to be in a jail. Huh? So before his arrest, you will submit the application and he'll get bailed for it. Okay. So this kind of this specific kind of bail is known as anticipatory bail. And now ad interim bail. Now ad interim bail is something that the during the time between an arrest. Okay, the time between an arrest, a person when it is an FIR is lodged or something, the time between that when the investigation is going on and whether this person is supposed to be arrested. So before the arrest, that time in whatever the bail is, given to the court, it's submitted in front of the court. That kind of bail is known as ad interim bail. Now, bail after conviction. Conviction is you have been, charged guilty of something, and after that you will be given the bail. Now, bail on default. For example, you are in jail, and then the investigation is going on and going on and going on, and it is taking a lot more time than it was supposed to. Now, this particular time was, you are not supposed to be in jail for that long period of time. Now, these kind of bail are given to you in that particular, situation. If the investigation is too long, you get bail on default. Now, let's see a sample of a bail. So, we have it here. Okay. So, bail in the court of, in the court of, you will write whatever your trial court is in front of whoever you are, you will write the same. And then additional district session judge of this and court this. Okay. In the matter of LMN, this is our petitioner, son of this years of age, working as whatever designation and residing at with the address. You'll write it like this only, petitioner versus the state of whatever, for example, Uttar Pradesh, the state of Uttar Pradesh, through PQR. Now, through PQR is the council for the state, because criminal offences are always dealt by a representative of the state. So the state, the council for the state, and the council is son of age this years, working as this, and residing as the particular address of the PQR. Now, this person is your respondent. Now, what is the FIR number? These are all the relative details. Now, this application is under section 439 of the Code of Criminal Procedure 1973, grant of bail. Now, you always have to mention these small things, okay? Most respectfully show that the present application, okay? Here he mentioned the FIR number specifically, okay? What police station it is, the present petition, okay? He arrest on given date. So it is all about, first paragraph mentions all the details of the case. For example, FIR number, which police station it was, when was the arrest happened, Now, apart from that, here, this is, is stating in front of the court that the petitioner is innocent and has been falsely implicated in the above. I'm so sorry. In falsely implicated in the above said case, as he has nothing to do with the matter. Now they are saying that the petitioner has nothing to do in a matter. He is completely innocent. And remember that whatever you write from your point two becomes your grounds for the bail. The reasons why you are trying to prove the judge that this why this person is not supposed to be in the jail. He must be allowed to be outside of the jail. Why your client does not deserve to be inside the jail? Why he is supposed to be outside? And it should be reasonable enough in front of the court. Okay, so you will have to mention like that only. Here it is, arguing that the petitioner is innocent. He has been falsely implicated for these specific thing that whatever has happened. Now there are certain things about all of these things, that petitioner is a law-abiding citizen. Now remember, the image of your client matters a lot, and you have to showcase it very nicely. Being a lawyer, you have to mention your client as a very law abiding, very pious person who is a very honorable citizen of your country. Even though it can be the other is true, of course, but it is your client and it is your duty to show that he deserves to be out of the jail. Okay, the petitioner is gainfully carrying on the business of this at this. Give details where he has been, working, or whatever details are required. Okay, it may be the residence of him, he, what locality he lives in, what work he does, how he has been throughout the session. You can also, in some cases, you can also mention, even though there can be cases where you will face the situation where the client of yours has a history in the criminal offenses or something, but you will mention how he has been working on himself in that case. You will basically have to mention everything that makes your client's image better in front of the court, okay, in a very respectable manner. Okay, it should not be too much, of course, but everything that benefits your client, you should mention. Here they are saying that he is innocent, he is a law-abiding citizen of India, he is working here, and petitioner is a responsible person and is living at the above mentioned address. Okay, give all the other relevant facts. Here they have mentioned that you have to give all the other relevant facts which proves that the petitioner is innocent. Now look, you have made a claim over here. Okay, you have made a claim over here in front of the court that the petitioner is innocent. You'll also have to show the court that how your petitioner, how your client is innocent, right? Whenever you are writing a bail application, if you claim something, if you claim that he's a very responsible person, he is this and he is that, you'll also have to show the relevant facts. Okay, now here they are claiming that he is innocent. Now they have to mention all the relevant facts that prove that he is an innocent person. Okay, all the relatable here, and that petitioner undertakes abide conditions. Now here he also mentions that whatever the court deemed to be necessary, whatever the court finds necessary for him to follow something, For example, they do not allow him to leave the city. Okay? Whatever conditions the court will make for letting him out from the jail, it is, accepted by the petitioner. You will also mention that whatever you say, I will abide by it. Okay? Here in this paragraph, they have again mentioned how he is innocent and what wrong happened or whatever happened. Now they are saying here that they will be okay with whatever the conditions will be, and that the petitioner has not filed any other similar petition before this or any other honorable court for grant of bail in case of present FIR. Okay, now they are mentioning that this is the very first time that we are coming for the bail in front of you. We have not approached you for this before. You can see the, it is not very much relatable, but yes, it is an example how your presence in front of the court matters. Your client's presence in front of the court matters. You see Patanjali's example. They did not answer the, court's summons. They were not present in the court, and they again and again asked for, apologies. They again and again apologized in front of the court. So this is not the case in this specific, bail. This is the first time he is a very innocent person. He is here for help. He wants to be out of the jail. This is how this specific lawyer is, mentioning that his client is. He is a very innocent person and he is in front of the court for the first time, and he must be out of the jail, and he seeks help of the honorable court for the same. Now, since you have mentioned all the facts related to that, since you have mentioned all the specifications of this, you will make prayers. Okay, you will make prayers. Before that, you'll no. Okay, so you'll make prayers, and prayer you'll write grant bail. Of course, your primary intention is to get bailed, right? So your petitioner should be grant a bail on FIR number this registered under this specific section for the offense of this specific thing. Give sections, of course, at the police station of the given place. And this line you will also mention, whatever the court, whenever you are writing your prayers, this line is very necessary. It is added all the times in whatever kind of a petition that there is. Whatever the court deems to be necessary, whatever they find that is necessary and can be done in the specific case, the court can do the same as well. Okay, you leave it to them. Now, element petitioner through ABC, the council. Okay, and then their place and dated this. Is it clear up until now? Okay. So we have done bail. Now that we have is what is an appeal. We have an appeal. The resort to a higher court to review the decision of a lower court, or to a court to review the order of an administrative agency. Now, what is an appeal? It's a very simple thing, you would hear again and again, this happened in the news. You will hear that this specific thing happened, and now this specific celebrity is going for this appeal in this specific court, right? So is there anybody who can tell me in the very simple language what is appeal to you? What do you understand by the term appeal? Anybody? Okay, there is nobody.
May I?
Of course. Yes.
Yeah. So it's when a lower court passes a judgment on the case, and the people who have filed, they have an issue and they are not okay with that judgment. So they have a chance to appeal to the higher court, where it can be that it goes against or in their favor.
Mhm.
So they usually go for an appeal, in the hope that the judgment will, maybe come in their favor.
Okay. Very nicely explained. I think that was Kritika, right?
Yes, ma'am. Yeah.
Okay, very nicely explained. So, as Kritika told us all, that there can be cases when party A is not happy with whatever the decision of a specific court is, or whatever order that an administrative agency has passed. Now, administrative agency has passed, for example, I hope that you all know about customs, right? आपने ये वाला word सुना होगा, customs and all. So these are agencies which look after some specific laws, and they deal with they have their specific courts, and they have their own method of proceedings and everything. Huh. So these specific administrative agencies sometimes passes orders for some specific thing, right? So in those cases, and in the case of a lower court, you know, what happens is that if a party is not happy with this, a party to a case is not happy with whatever the judgment or the order passed by a lower court or administrative agency, they would resort to a higher court. They would seek a higher court for reviewing the decision or the order made by the lower court or administrative agency, to see whether the decision was right or wrong. There can be chances that the decision can be changed. The order can be changed by the higher court. Remember that once you are gone to a higher court, you cannot go to a lower court or to an administrative agency. You only go from lower to the upper courts, and not the other way around. Okay. So, mm, and I have this document has one good thing about this specific appeal, that this is provided by Assam State Portal only. So this appeal is a format that a specific government of a state has provided on their official site. So this is if you apply for an appeal in Assam Higher Court or somewhere, you are supposed to follow this particular format. You see, is it visible to you all? Okay, remember that. Similarly, even though the pattern and the format stays similar, there can be very minor changes state-wise according to the courts, which will be visible on their specific, what you call it, the sites of the ministries or some government site. They will provide the format. If that, if that there is some specific requirement only, they provide these kinds of format. So you before going, before going to draft all of these things, must check once that whether the state has a specific format of it, and if not, you can use these general formatting. It is all right. But if this state specifically provide, like the Assam state provides, you will follow that specific format only. Is it clear to you all? Let me see the thumbs ups. Okay, thank you so much. So in this specific format, we keep the dates and the location here on the right side of my screen. Then from the applicant's full name, his postal address, telephone number, and email if there is any. Now, who this application is going to, who this specific appeal is going to, the first appellate authority of public authority. For example, you are going to the higher court, you will mention that I'm going to the higher court for this specific thing. Now, full postal address of the public authority, where that public authority is. Remember, the court is the judge, not the building, of course. So you will write proper address where the judge is, like not his home, of course. Wherever the court is held, wherever the judge sits and looks after the proceedings, wherever the judge held his proceedings for different cases, that specific address is supposed to be mentioned. Now your subject, appeal under this specific section of this specific act of the year. Now now you mention information RTI Act. You give all the references about you and your specific office. Sir, ma'am, your officer name, the designation and address, telephone number against whom the appeal is preferred. Okay, let's assume that this is an appeal against an administrative agency. Okay, so you have to mention that here. Now, particulars of the person, name and date, if any, briefing of the fact. You'll write all the facts that has happened. For example, there is this person who has all his belongings. There is a thing called search and seizures under Section 67 of the Goods and Services Act. I hope that you guys know. So what happens is that if the police in charge has, the magistrate has a specific reason to believe that the person is, that there has to be a search and seizure of property of a certain person, they do that. So now, but they do need to mention all the, reasons why are they doing this search and seizure. They have to give the notice. Now, a person was there and a search and seizure happened and he was given the notice, but that notice did not mention why the search and seizure was happening, right? So it was not following the procedure, right? So he will mention that, sir or ma'am, that search and seizure happened, but I was not informed why it happened. So that there was no reason to believe on the first place that my place must be searched and any document must be seizured, that is not wrong and that is not okay. I have been wronged. So all these kinds of the facts you will have to mention here. So whatever happened in your case, you will mention here very nicely, precisely, not in a very long manner, but yes, in a short manner. Okay. Now then, your prayers and relief, like what are you seeking for and all? Appeal for the grounds of the prayers and relief. What are your grounds and all? Verification by applicant, whatever documents he says that this information that I am providing is true to all my knowledge. As far as I know, it is true. And I say that publicly, I clear that. Okay, so these are the documents that are required. Or photocopy and original copy of self-attestation, copy of acknowledgement, okay, receipt application. I would suggest you guys take a screenshot of this. Okay, all the documents that are supposed to be attached, you guys take a screenshot of this, and I would suggest you, once you go through all of these, you search about the same in what different cases, because different cases might need different kind of documents. Okay, so I would tell you that whatever documents that are necessary for a specific case, you guys go through Google or whatever authentic resources that you have and check what are the documents that are necessary. Now this person is doing his signature, your appellant, huh? This person is doing his signature or thumb impression with that their name. So this was all about your appeal. So after appeal, we have revision. Now revision is something that a person seeks. It is a kind of remedy that you seek. It is very much similar to appeal, but not appeal. So you go to a superior court. For example, there is this specific decision made by a lower court and then a district court. Let's say a trial district court, there was this specific decision was made and you are questioning its legality. You think it is legally not wrong, it is not proper, something has not been done right. So for that, you want a superior court to look after that specific decision, how legal it is, how proper it is. Okay, so in case somebody murdered your best friend, okay, let's get a little dark with this. So since we are studying about criminal cases, somebody murdered your very, very dear friend and the court says that it was not murder, it was something else. The person was not okay and he committed suicide. Now you are, questioning its legality. Or the weapon was not used by the accused, it was used by somebody else. You are questioning the whole procedure, the decision, whether it is legal or not. Maybe on the basis of law, maybe on the basis of fact. Remember that facts always change in every case. Every case there will be a different fact. There will be a different kind of approach in every case. Okay. So laws remain the same, but fact changes and that changes all the, basis of the case. That changes everything. So in times you question the legality of the decision. Everything is not, in Hindi we say a patthar ka lakir. Whatever is written in our books, that is very necessary, definitely. But with the facts of a criminal case, everything changes. So sometimes you question the legality and propriety of the court. What they have done is maybe not legal. So what you do is you go to a superior court, you tell them, you request them, not tell them, you request them, kindly check the legality of this particular decision or order passed by this particular subordinate court because of some specific reasons. Let's go and see how do we apply for a revision. So you apply for a revision petition. Now it is not a single paper document. It is a proper petition that you will have to give. So it will take time. I want you guys to be very attentive because there is a lot of pages here. I do not want you guys to get scared. It's just a normal thing. It is a combination of what we have seen up until right now. It is not very complicated, very easy, long, but very easy. Okay. So, criminal revision petition number. First of all, you will write your petition number, then FIR number of the case, then police station, next date of the trial court, and in the matters of the name of the petitioner, like this. Okay, we can do this here. Oh, I'm sorry. Yep. Now versus the state ABC PDF whatever, considering the fact that this is a criminal case, of course, the state will be there. If there is any specific person or the council, these are your responding. In every document, you are supposed to mention your respondent and your petitioner very clearly. First of all, that is the first thing that you are supposed to do. Now, this specific stanza here, this specific paragraph here mentions that what all the details of the FIR are. So it mentions under which section of the Criminal Procedural Code it has been mentioned, and then they are praying for quashing and setting aside the order dated this in FIR number this, FIR's date here. Okay, under section this of Criminal Procedural Code in Metropolitan Magistrate. See, this is to a magistrate. Remember, see, when you are mentioning the court, okay, you're mentioning the court, remember that there will always be a higher court than your previous court. Okay, so whatever court you are going to, you must mention that. From whoever the court it was. For example, here it is the order that was passed was by this specific lower court. Now they want the higher court to quash that and set aside. Now this respectfully is now this person is respectfully telling all the details. Now this happened with him. This happened in the trial court and hearing on this date specifically. Where he resides is a peace-loving person. The complainant is approached accused through one accused number this for purchase of one property. There is these are all the facts. Okay, facts can be different. Facts are different, of course. Facts are always different. But you will mention all the details in precise manner, in very specific manner, that what happened, what was the property number, whatever the details that are necessary for this document, you will tell everything. So this number was, this amount of money was given. This amount of money was given by a check and drawn on what date, by number this. Okay, they are mentioning how the transaction of money happened. Okay, so if there is money involved, you will inform what were the methods of transferring money from one person to another, or there is a transfer of a property, let it be anything, a movable property or an immovable property. There is a transfer, you will mention everything about that. Okay, how the payments were made, whether they were made or not, receipts. Now, whatever documents were necessary, whatever the payments were made, you'll attach the receipts to that. Okay, from received with thanks from this person. Okay, who from whom you received and by whom it was received. The balance was this. Okay, is to be paid on or before. See, up until now, what we have done is we have mentioned the basic, structure. We mentioned our petitioner with all the details. We mentioned our respondent with all the details. Then we mentioned what we are, basically, it is, a subject kind of a paragraph. You mentioned what you want. It is a very introductory, very small paragraph. And then you mention all the facts of the case with all the relevant information that is required to be here. That is all we have done. Now, this information can involve receipts from the bank, all the required documents from other authorities that are given to your client or whoever it is. Okay, if you are from the petitioner side, there can be a lot of documents involved, so you'll have to attach the copy of them or the original ones. Most of the time original ones are not attached. You attach a copy of the same and keep the original one, of course, with you. Now, once these are done, see, entire business amount. Now they are specifically telling how much amount was there. You'll have to be very precise with all of these things. See, petition, even though I know that this is a very long document and you'll have to draft it, but remember that it is not a very complicated thing once you understand how to write the facts. Mostly facts are written very specifically in a crisp manner, but in an informative way. You will have to, of course, work upon your language. That comes with practice only. So if you try right now, I would suggest you, once you get these documents, you will go through them and try to find cases. For example, take some famous cases, landmark judgment. Take any case from MC Mehta or whoever is, your favorite. Take your favorite case, criminal one or whatever, of course, criminal one, and try to, make the copy of these documents with the facts of that case only. Practice on yourself. You'll get to, know what your weak points are, what you are lacking. This language that we use, it comes with practice only. I can tell you whatever is necessary, but on the with that you will have to practice by yourself again and again. Even if you are not as good as this right now, or even better than this, there are people even better than this, of course. So even if you are not as good as right now, but one day that you will be. Of course, even I am learning myself. I try to learn all of these things every day. Okay, so even if you are not able to make documents like this, write facts like this, you don't have to get disheartened by that. Just keep on practicing how to write the facts, and one day you'll know how to write them. Keep joining workshops like this. You'll get to know a lot more things from different people. And of course, law article is trying to provide as much as workshops as possible for you all. So again, we are going very far away from the topic. Let's come back here. So here are again the facts of the case. You see. So there are all these facts, which case they are, which sections they are using in a specific thing, what are the police station that they have been, whatever happened in the previous case that is necessary to be mentioned, they will mention. Then now you'll have to mention the grounds for the revision. You mentioned all the facts over here. Now, once you have provided the facts, you'll have to mention what are the grounds for the same, what are the grounds to support that, right? So you'll mention the ground. You'll mention why it is necessary, what is the important thing that is supposed to be done. Why do you think that this is like a specific thing? If something wrong, if it is not legal, why it is not legal? So these grounds you will mention after it. Okay, so they are here mentioning why principles of natural justice and everything they are talking about. So whatever legal technicalities which which strengthen your facts, which strengthen your argument over here. Okay, you will have to mention them in the grounds. Okay, that the principle of natural justice was not followed. I was not heard properly. The system was not working properly. These small things you can mention for your grounds. Particular document was not considered before the decision was made, and these all things you will mention, basically depending upon the case, what all are necessary. Okay, so you will mention all the relevant grounds relative to your facts, which prove them, which strengthen your facts, and then you will pray. You will do your prayer in front of the court. So they are telling that to the honorable, they are requesting to the honorable court to examine the records and check whether they are correct or not. Okay, and then once they are checked, if it is wrong, if it is not legally proper, then please quash and set aside the specific order or decision of the specific court. Okay, now what is quashed and set aside? That the decision that was made by the court is not relevant anymore, is not in you know in implication anymore. It will not imply, it will not be legally abiding on the parties. It will be quashed, that is crushed aside. It will not be implicable on the parties anymore. That is what they are requesting here. Okay, that the case be remanded to trial court for further evidence. Okay, now they are asking, they have some specific request from the court that you can make. And of course, as I told you earlier, anything that the court seems that it is necessary, they can make a decision over that or put it into an order. Now petitioner through the advocate again, and that's all. Of course, there are your signs here. Of course, the advocate has to attach their stamp and everything. So you will, once you become an advocate, or if you are an advocate, if you have anybody in family that is an advocate, you will know that you guys get a stamp and proper thing. You will attach your what do you call it in Hindi, wakalat nama here with this. First, why are you here? So you are the advocate to the petitioner. You do that. The petitioner will sign here,